Doctrine of fair comment. A doctrine in the law of libel which means that while in general every discreditable imputation publicly made is deemed false because every man is presumed innocent until his guilt is judicially proved, and every false imputation is directed against a public person in his public capacity, it is not necessarily actionable. In order that such discreditable imputation to a public official may be actionable, it must either be a false allegation of fact or a comment based on a false supposition. If the comment is an expression of opinion, doctrine of equality of shares. The doctrine that all stocks issued by the corporation are presumed equal with the same privileges and liabilities, provided that the OE is silent on such differences. Also called equality of shares doctrine. Doctrine of equality of shares. Doctrine of election of remedies. A doctrine developed to prevent a plaintiff from a double recovery for a loss, making the person pursue only one remedy in an action. Although its application is not restricted to any particular cause of action, it is most commonly employed in contract cases involving fraud, which is a misrepresentation of a material fact that is intended to deceive a person who relies on it. Doctrine of election of remedies. Doctrine of effective occupation. A doctrine in intel law which holds that in order for a nation to occupy a coastal possession, it also had to prove that it controlled sufficient authority there to protect existing rights such as freedom of trade and transit. Also called effective occupation doctrine. Doctrine of effective occupation. Doctrine of effective occupation. A doctrine in intel law which holds that in order for a nation to occupy a coastal possession, it also had to prove that it controlled sufficient authority there to protect existing rights such as freedom of trade and transit. Also called effective occupation doctrine. Doctrine of effective occupation. Doctrine of a justum generis. Con. The doctrine under which where gen terms follow the designation of particular things or classes of persons or subjects, the gen term will be construed to comprehend those things or persons of the same class or of the same nature as those specifically enumerated. Napacor v. Ungas, GR 60225-May 8, 26, 1992, 208 SCRA 542. Doctrine of Equivalents Test. Intellectual property. A test established to determine infringement which recognizes that minor modifications in a patented invention are sufficient to put the item beyond the scope of literal infringement. Thus, an infringement also occurs when a device appropriates a prior invention by incorporating its innovative concept and, albeit with some modification and change, performs substantially the same function in substantially the same way to achieve substantially the same result. Godines v. Ka, GR 97343, September 13, 1993, 226 SCRA 338. Compare with literal infringement. Doctrine of Equivalents. Intellectual property. The rule stating that an infringement also takes place when a device appropriates a prior invention by incorporating its innovative concept and, although with some modification and change, performs substantially the same function in substantially the same way to achieve substantially the same result. SmithKline and Beckman Corporation v. Ka, GR 126627, August 14, 2003, 409 SCRA 33. Doctrine of Equitable Recoupment. It provides that a claim for refund barred by prescription may be allowed to offset unsettled tax liabilities should be pertinent only to taxes arising from the same transaction on which an overpayment is made and underpayment is due. Doctrine of Exhaustion of Administrative Remedies. Exceptions to the rule. A. The question involved is purely legal. B. The admin body is in estoppel. C. The act complained of is patently illegal. D. There is an urgent need for judicial intervention. E. The claim involved is small. F. Grave and irreparable injury will be suffered. G. There is no other plain, speedy and adequate remedy. H. Strong public interest is involved. I. The subject of the controversy is private law. J. The case involves a quo warranto proceedings on Val Timber Products, Incorporated v. Abad 206 SCRA 482 1992. K. He party was denied due process Samahang Magbubuk NG Kapila, Incorporated v. CA 305 SCRA 147 1999. L. The decision is that of A. Department Sec Nazareno v. Ka. GR 131641, February 23, 2000. M. Resort to admin. Remedies would be futile. UP Board of Regents v. Russell 200 SCRA 685 1991. N. There is unreasonable delay. Rep. v. Sandigan Bayan 301 SCRA 237 1999. O. The action involves recovery of physical possession of public land. Gabrito U. CA 167 SCRA 771 1988. P. The party is Porcebello v. DECS 180 SCRA 623 1989. NQ. The law provides for immediate resort to the court. Rulian v. Valdez 12s. Doctrine of Election of Remedies. A doctrine developed to prevent a plaintiff from a double recovery for a loss, making the person pursue only one remedy in an action. Although its application is not restricted to any particular cause of action, it is most commonly employed in contract cases involving fraud, which is a misrepresentation of a material fact that is intended to deceive a person who relies on it. Doctrine of Estoppel by Laches. Law. An equitable doctrine by which some courts deny relief to a claimant who has unreasonably delayed or been negligent in asserting a claim. A person invoking laches should assert that an opposing party has slept on his or her rights and that the party is no longer entitled to his or her org. Doctrine of Executive Privilege. The doctrine stating that the Pres and those who assist him must be free to explore alternatives in the process of shaping policies and making decisions, and to do so in a way many would be unwilling to express except privately. These are the considerations justifying a presumptive privilege for personal communications. The privilege is fundamental to the operation of GOVT and inextricably rooted in the separation of powers under the Constitution. Almonte v. Vasquez, GR 95367, May 23, 1995, 244 SCRA 286. Subscribe for more. Doctrine of Executive Privilege. Doctrine of Exhaustion. The doctrine that provides that the patent holder has control of the first sale of his invention. He has the opportunity to receive the full consideration for his invention from his sale. Hence, he exhausts his rights in the future control of his invention. It espouses that the patentee who has already sold his invention and has received all the royalty and consideration for the same will be deemed to have released the invention from his monopoly. The invention thus becomes open to the use of the purchaser without further restriction. Adams v. Burke, 84 U.S. 17, 1873. Also Doctrine of First Sale. Subscribe for more. Doctrine of Estoppel. Law. A doctrine based on grounds of public policy, fair dealing, good faith and justice, the purpose of which is to forbid one to speak against his own act, representations, or commitments to the injury of one to whom they were directed and who reasonably relied thereon. PNB v. Ka. GRL 30831, November 21, 1979, 94 SCRA 357. Doctrine of Finality of Administrative Action. The doctrine in Paul law that prior to the completion or finality of the action of an admin agency, courts will not interfere with it for the reason that absent a final order or decision, power has not yet been fully and finally exercised, and there can also be no irreparable harm at that point. Subscribe for more. Doctrine of Exhaustion of Administrative Remedies. The general rule that before a party may seek the intervention of the court, he should first avail of all the means afforded him by admin processes. The issues which admin agencies are authorized to decide should not be summarily taken from them and submitted to a court without first giving such admin agency the opportunity to dispose of the same after due deliberation. Rep. v. Lacap, GR 158253, March 2, 2007, 517 SCRA 255. Subscribe for more. Doctrine of Hierarchy of Courts. Law. An established policy that parties must observe the hierarchy of courts before they can seek relief directly from the SC. The rationale for this rule is twofold: A, it would be an imposition upon the limited time of the SC, and B, it would inevitably result in a delay, intended or otherwise, in the adjudication of cases, which in some instances, had to be remanded or referred to the lower court as the proper forum under the rules of procedure, or as better equipped to resolve the issues because the SC is not a tier of facts. Heirs of Anog v. Melliker, GR 140954, April 12, 2005, 455 SCRA 460. Subscribe for more. Doctrine of Governmental Immunity from Suit. The doctrine that no governmental body can be sued unless it gives permission. Subscribe for more. Doctrine of Free Enterprise. A doctrine holding that a capitalist economy can regulate itself in a free and competitive market through the relationship of supply and demand with aim and intervention and regulation from the state. Subscribe for more. Doctrine of First Sale. A doctrine in intellectual property law wherein the owner of an intellectual prop, such as a patent, loses or exhausts all his rights to the good subject of the intellectual property right after its first sale in the market. Also called Doctrine of Exhaustion. Subscribe for more. Doctrine of Fair Use. Property. The doctrine that permits a secondary use which serves the copyright objective of stimulating productive thought and public instruction without excessively diminishing the incentives for creativity. Also called Fair Use Doctrine. Doctrine of File Wrapper Estoppel. The doctrine holding that a patentee is precluded from claiming as part of patented product that which he had to excise or modify in order to avoid patent office rejection, and that he may omit any additions which he was compelled to add by patent office regulations. This doctrine balances the Doctrine of Equivalents. Subscribe for more. Doctrine of Finality of Administrative Action. The doctrine in Paul law that prior to the completion or finality of the action of an admin agency, courts will not interfere with it for the reason that absent a final order or decision, power has not yet been fully and finally exercised, and there can also be no irreparable harm at that point. Subscribe for more. Doctrine of Forum Non-Convenience. The forum is inconvenient. A rule designed to deter the practice of global forum shopping, Kakuya and Agaling Pangalangan, Conflicts of Laws, pages 40-41, 2000 ed. That is, to prevent non-resident litigants from choosing the forum or place wherein to bring their suit for malicious reasons, such as to secure procedural advantages, to annoy and harass the defendant, to avoid overcrowded dockets, or to select a more friendly venue. Under this doctrine, a court, in conflicts of law cases, may refuse impositions on its jurisdiction where it is not the most convenient or available forum and the parties are not precluded from seeking remedies elsewhere. First Phil. Intel. Bank v. Ka. GR 115849, January 24, 1996, 252 SCRA 200. Doctrine of Holdover. The doctrine under which a public officer whose term has expired or services have been terminated is allowed to continue holding his office until his successor is appointed or chosen and had qualified. Subscribe for more. Doctrine of Holding Out. The Doctrine of Immunity from Suit. the doctrine the application of which has been restricted to sovereign or governmental activities jure imperi. The mantle of state immunity cannot be extended to commercial, private and proprietary acts jure gestionis. Jusmeg v. NLRC, Gr 108813, December 15, 1994, 239 SCRA 224. 2. The restrictive application of state immunity is proper when the proceedings arise out of commercial transactions of the foreign sovereign, its commercial activities or economic affairs. Stated differently, a state may be said to have descended to the level of an individual and thus can be deemed to have tacitly given its consent to be used only when it enters into business contracts. It does not apply where the contract relates to the exercise of its sovereign functions. USA v. Ruiz, GRL 35645, May 22, 1985, 136 SCRA 487. Subscribe for more.